my name's Jim Bonebrake. I'm an attorney with the Patterson Law Firm. The Patterson Law Firm has been handling claims for consumers and small businesses against their banks for what's called third-party wire transfer fraud cases. What is wire transfer? Wire transfer, also called a bank-to-bank transfer, is a transfer that's created to immediately move money from one bank to another. You request your bank to send money to another bank, and then that bank will send the money and put it into the account of the person that was your intended recipient of that money. Rather than you sending the money directly to the recipient, the banks are involved, which allows the money to be transferred almost instantaneously, which is great. You've probably knowingly or unknowingly been involved in a wire transfer. For example, a closing of a house where the seller wants your earnest money or down payment immediately at the closing and is not going to sign off on the documents for the sale until you transfer that money. This sort of transfer allows for the immediate transfer, and then the deal can be closed. It's a great situation in terms of getting money out of the account quickly for that purpose, but the flip side is that it's ripe for fraud because the money is transferred out quickly and it's so hard to get it back once it's put into that account. And what will happen is that the sophisticated third-party cyberspace fraudsters will do things in a sophisticated way to access your account, like spoof or imitate the bank's normal business number, calling you and saying that they're a member of the anti-fraud department trying to prevent fraud from your account, when in fact they're doing just that. And they get you to give them particular information about your account, confidential information, which then allows them to get at your money. Now you may say to yourself, why am I worried about this if I never do wire transfers? Banks would never allow that to happen if I don't do wire transfers. Unfortunately, that's just not true. For 20 years, banks have been allowing these types of frauds to occur without looking more carefully and having a red flag alert them to contacting the customer and make sure the customer wants the transaction. Instead, they allow the transaction to go forward. Then when the customer complains, they blame the customer for having inadvertently divulged the contact information. It is a shame and it's shameful. And that's not the law. Fortunately, the law is set up to require the banks to use what's called commercially reasonable security procedures to prevent just this type of fraud. For example, if the size of the wire transfer is great relative to the amount of money in your account, or if the transfer is going to a foreign bank in another country, or if you've never had a wire transfer, these should be red flags, which should make the bank more vigilant to contact you and confirm directly that you want the wire transfer. At the Patterson Law Firm, we painstakingly go through the records to confirm whether or not the bank employed in good faith commercially reasonable security procedures. Did they use what's state of the art? For example, you've probably heard of the term multi-factor authentication. Did they use that? Did they use algorithms or computers to set up data risk profiles to see if the transaction that is at issue is different from your normal pattern of activity? And if it is, that should alert them to the fraud risk. And when they don't use these security procedures in a good faith way, we have been able to get the money back for our clients with interest. And we can do that for you. If you've been defrauded by third-party wire fraud, give us a call.